When a relationship breaks down, the natural instinct is to assume your next step is a courtroom. You hire a lawyer, you file a petition, and you present your case directly to a judge to sort out the money and the children. But the modern family court system is facing a massive backlog. This chart shows the reality. Cases can take 4 to 6 months just to secure a first appointment. A final hearing requires even more time. To address this congestion, the law requires almost everyone to attempt a mediation information and assessment meeting, or MIAM, before they are even allowed to file most family court applications. Bypassing this step carries strict penalties. Judges have the authority to halt proceedings, refuse to hear your case entirely, or even impose financial sanctions on parties who bring unnecessary private litigation to the court. The courts prefer you negotiate because the data proves it works. Couples who reach an agreement through mediation spend an average of £1,641, resolving their disputes much faster and with far less bitterness than a full trial. By enforcing procedural hurdles and the threat of sanctions, the legal system actively prevents couples from treating the courtroom as their first option, using financial and procedural pressure to force communication instead. For mediation to succeed, it requires a foundation of open communication, a mutual willingness to compromise, and a relatively equal balance of power between both individuals. This creates a structural problem. When a relationship ends in abuse or severe dysfunction, forcing those separating couples back into a room together can be physically dangerous, practically impossible, or entirely pointless. To account for this, the law provides specific safety valves. These formal legal exemptions to the MIAM rule must be officially verified. You prove this to the court using Form FM1, which requires an authorized mediator's signature confirming your exemption applies. These documented exemptions exist to ensure the rigid requirement to mediate doesn't become a trap for vulnerable people who genuinely need immediate judicial intervention. The first and most critical category of these exemptions is focused entirely on protection and safety. The mediation mandate is waived immediately if there is clear, documented evidence of domestic abuse. This can take the form of an ongoing police investigation or an existing protective injunction. The waiver also applies if there is an urgent risk to the life, safety, or home of the applicant, or if social services are already involved due to concerns over child welfare. The legal framework recognizes that a victim cannot negotiate fairly while under the threat of violence or coercive control. In those scenarios, the balance of power is simply too distorted for mediation to function. In matters involving physical safety and abuse, the court prioritizes immediate, binding protection over its own mandate for alternative dispute resolution. The second category of exemptions covers logistical impossibility. The system acknowledges that it cannot force an outcome that physically cannot happen. You are granted a legal exemption if the other party is currently in prison, living abroad, or if their whereabouts are completely unknown despite reasonable efforts to locate them. This map shows a specific geographic rule. If there is no authorized mediator available within a 15-mile radius of the applicant, the requirement is waived. It is also waived if a party has a disability that the mediation facilities cannot physically accommodate. The final category is administrative redundancy, which covers scenarios where forced mediation is legally deemed a waste of time. This applies to financial disputes where one party is already bankrupt, or cases where the couple has already reached an agreement and is simply submitting a consent order. It also applies if mediation was already attempted unsuccessfully within the last 4 months. The law refuses to force participation in a process if physical, geographic, or administrative realities guarantee it will fail. The MIAM process functions as an intentional filter for the family court system. This selective filtering process preserves the court's heavily strained time and resources strictly for the cases that desperately require judicial intervention. The law effectively creates 2 paths. Safe, manageable disputes are directed to the negotiation table to save emotional and financial costs, while high-risk cases receive a documented fast track to a judge. For individuals navigating this system, understanding these specific rules allows you to approach family law with confidence in your rights, knowing exactly when to negotiate and when to litigate. The family court system demands cooperation as the default, ensuring alternative dispute resolution is utilized as a tool for peace, while maintaining rigid exemptions to protect the vulnerable from harm.